Hi, I'm Fiona Kirkman from FamilyProperty, and in today's workshop, I'm going to cover family property tips number 2, dispute resolution after the commencement of family law proceedings. The new case management pathway provides for pre-action procedures, including dispute resolution prior to initiating court proceedings, as well as dispute resolution for parenting and financial matters after the commencement of court proceedings. The central practice direction sets out the family law case management pathway. It provides for the pre-action requirements prior to the commencement of court proceedings, as well as dispute resolution as part of the court events. This is a mandatory practice direction that it should be given by family lawyers to clients before the commencement of proceedings, and is also helpful for family dispute resolution practitioners. The central practice direction in particular notes that within 5 months of commencement of proceedings, parties are required to participate in dispute resolution in both parenting and financial matters, unless exceptional circumstances such as family violence, safety concerns apply. There's also an assessment of the means and capacity to pay for private dispute resolution as opposed to court-based dispute resolution. If the matter is appropriate for external dispute resolution, parties will be referred to mediation, such as with a nationally accredited mediator. Family dispute resolution, and Section 13C provides that the court may refer parties out to family dispute resolution, and arbitration by consent. Alternatively, if the matter is appropriate for court-based dispute resolution, parties will be referred to a conciliation conference, and there's a new conciliation conference brochure, a judicial settlement conference, a family dispute resolution conference under Section 13C1B with a judicial registrar who's also an FDRP, and where appropriate, a court child expert. And again, there's a brochure about the court-based family dispute resolution, which sets out information about the process and what happens in FDR, including Part 1 and Part 2. All dispute resolution is confidential, and all parties will be expected to engage in good faith negotiations and make a genuine effort to resolve all disputes. As we know, there's a big focus on dispute resolution, but there is also a focus on compliance. And in the event a party does not attend or is not compliant with orders, directions, or the family law rules, consequences or other consequences may follow. So what documents are required for mediation or external family dispute resolution? So unless the court otherwise directs, or the parties and the mediator/family dispute resolution practitioner all agree, no less than 7 days prior to the mediation or family dispute resolution event, they're required to prepare and exchange 9 separate documents. 1, all relevant court documents, including, for example, the applications, response, affidavits, financial statements filed in the proceedings, any relevant expert reports, such as business valuations, property valuations, etc., any document exchange between the parties relevant to an issue in dispute with the relevant passages highlighted. As an example, I recently had a mediation and asked them to highlight the relevant transactions on the bank statements as to the transactions that had question marks over them. A minute setting out the precise orders of parenting property orders. Good news is FamilyProperty automates now the property and parenting orders in draft form. A confidential case outline document in the approved form. Now that's what I'm going to showcase, the new smart form for the confidential case outline, but you should be aware that you can't use your old case outline. There's now standardised approved form. In a financial case, particulars of any financial resource. So for example, if there's an expected inheritance or interest in trust, that needs to be provided. Any valuation or market appraisal, only where the valuation is in dispute. The most recent super statement, and written confirmation that procedural fairness has been afforded to the super trustee if a super splitting order is sought. Any current or previous family violence orders, and of course this is relevant to suitability. A certificate of dispute resolution. So this is a new form that the applicant to the proceedings must give the mediator or family dispute resolution provider or the court to complete, and the mediator, FDRP, as an example, needs to confirm the conduct of the parties, whether they attended, made a genuine effort to resolve the issues in dispute, and whether they complied with cost notification requirements under the rules. That needs to be signed and then filed by the applicant. And lastly, any other documents reasonably requested by the mediator, family dispute resolution practitioner. So let's take a look at the new Family Property Smart Form for the confidential case outline. If you're a Family Property subscriber, you'd be familiar with Family Property, and if you're not, we'd love to provide a demo. There's three main parts to Family Property: the questionnaire, asking questions from the clients to gather the right information; the dashboard, which you can see here, which is made up of the interactive balance sheet, interactive parenting calendar, information about their current situation, personal details, considerations, and then disclosure, two-way disclosure to share documents with the other side. If you're familiar with the working balance sheet, we have the identity, ownership, value, and you can model various proposals, all auto-calculating, and then you can model out, for example, what a 55-45 split looks like. So that's all populated from the questionnaire or the dashboard. And then when you come to more smart forms, we have a new confidential case outline for the FCFCOA. Now, this confidential case outline provides some information about it, that it's on a without prejudice basis, not to be placed on the court file, privileged, etc. And then it provides the information in the form in a smart form, electronic form. So filed on behalf of, filed on behalf by the applicant, respondent, the party's details, the documents relied on, so the name of document filed and date of filing. If there's parenting proceedings, yes, no, and then some information as to agreed or partially agreed arrangements, then description of the agreement, briefly outline the issues relevant to the best interests of the children, briefly outline any changes to the arrangements identified in the questionnaire parenting. So as you would know, there's now a requirement if you're filing for parenting proceedings to also file a questionnaire parenting document. Also briefly outline any domestic and family violence orders made or varied since proceedings were commenced. So fill in that information, just add the relevant information, and that will populate into the form. Financial proceedings, so if yes, we'll automatically compile the whole balance sheet with the assets, liabilities, superannuation and financial resources for you. Then you need to briefly outline the relevant issues under Section 79 or Section 90 SM of the Act. And then contributions, so whether contributions in a percentage term for the applicant and respondent, and future needs or Section 75(2) adjustments, if any. We will also populate the overall division from the balance sheet, as well as, if you've used the balance sheet and modelled out a proposal, the items that are being retained by your client. Lastly, there's a chronology that is just relevant to the issues in dispute. So if the dates of birth, relationship details are not in dispute, it's only the chronology of the issues in dispute. Issues relevant to maintenance, spousal maintenance, including need and capacity. So you can save that and then download the relevant form. And I'll bring the form across now. So as you can see here, the form auto-populates with the parties' details, the documents relied upon, the parenting proceedings and the information that you've completed there. It automatically populates the whole balance sheet and auto-calculates the assets, liabilities, superannuation and totals. It sets out the information about contributions, future needs and overall percentage sought, as well as the property retaining by your client, chronology and maintenance. That needs to be certified by you as the lawyer if you're acting for your client or the applicant respondent. So I hope you found that helpful in showcasing the new confidential case outline and how that assists. Lastly, wanted to show you other preparation that's needed. So as we've seen, there's 9 separate different types of preparation you need to do for the mediation or family dispute resolution event that needs to be exchanged 7 days prior to that event. But in addition to that, you also need to ensure that you've complied with your duty of disclosure under the new Chapter 6 of the duty of disclosure rules here, disclosure and subpoenas, no later than 14 days prior to the mediation or family dispute resolution event. As we've said earlier, comply with all requests and make a genuine effort to resolve the dispute. Importantly, with regards to costs, in advance of any external dispute resolution event, you must provide to each party and your client the total costs and disbursements incurred by the party in the proceedings to date, an estimate of the anticipated costs expected to be incurred in each remaining stage of the proceedings, an estimate of the likely duration of the final hearing, and the total anticipated costs and disbursements expected. So really important cost notices as well as disclosure. Lastly, if it does not resolve at the external dispute resolution event, as you know, you need to file the certificate of dispute resolution, but also within 7 days, you need to provide a written notice to all other parties of the issues in dispute, the expected duration of the final hearing, and in relation to represented parties, the expected costs of and up to the final hearing. So disclosure, cost notice, as well as that written notices to the issues in dispute, in addition to the preparation, including that confidential case outline. I hope you found this helpful in demonstrating the dispute resolution process after the commencement of court proceedings. If you're interested to learn more, please book a demo or a refresher session in the link provided. Thank you.